Good morning, good afternoon, good evening. My name is Bailey Fernandez, and I will be doing a presentation on the lack of training in the criminal justice system, specifically focusing on mental illness. So, to get started, what is a mental illness? Mental illness refers to a range of mental health conditions that affect a person's thinking, feeling, behavior, or mood. These conditions can make it difficult for someone to cope with daily life, manage relationships, and even function effectively in society. Mental illnesses can vary in severity and they may be temporary or long term. And some examples include depression, anxiety, schizophrenia, and bipolar disorder. It's important to recognize that mental illness is a medical condition, not a personal weakness, and it often requires professional treatment and support. Individuals with mental illness are falling through the cracks of social safety nets, landing in the criminal justice system at high, alarming rates. That being said, the criminal justice system in the United States is often ill equipped to handle the unique needs of individuals with mental illnesses. Police officers, court officials, and correctional personnel frequently lack the specialized training required to effectively interact and support mentally ill individuals. This leads to a range of negative outcomes, including inappropriate use of force, wrong arrest, unjust legal decisions, and inadequate mental health care within correctional facilities. Addressing these training gaps is crucial for ensuring that the criminal justice system can provide fair and humane treatment to all individuals regardless of their mental health status. So to get started, we're going to start by looking at some case law. These two cases are relevant to the information that is going to be talked about throughout this course. So the first case to look at is San Francisco versus Sheehan, which took place in 2015. The case of City and County versus San Francisco versus Sheehan involved a legal dispute over the application of the Americans with Disabilities Act. Teresa Sheehan was a woman who had a history of mental illness and was living in a group home when she threatened her social worker with a knife. The social worker called the police, who attempted to subdue her, but Sheehan did not comply, and she threatened the officers as well. The officers then forced entry into her room and shot her multiple times, believing that she posed a significant threat to those who were around her. Luckily, Sheehan did survive, but she went on to sue the City and County of San Francisco, arguing that the police violated her rights under the ADA by failing to reasonably accommodate her mental illness during the encounter. The case did reach the U.S. Supreme Court, where the key issues were whether the ADA applies to police arrests and whether the officers were entitled to qualified immunity for their actions. So the Supreme Court did not fully resolve the ADA issue, but did rule that the officers were entitled to qualified immunity, meaning that they could not be held personally liable for their actions in this case. The next case to look at is Kaler versus Kansas, which took place in 2019. And this is also a U.S. Supreme Court case that addressed whether a state can abolish the insanity defense in criminal trials. James Kaler was convicted of capital murder in Kansas after killing 4 of his family members. Kansas law did not allow Kaler to use the traditional insanity defense, which would argue that he was not responsible for his actions due to severe mental illness. Instead, Kansas only allowed a more narrow mental illness defense, where a defendant could argue that they lacked the intent necessary for the crime due to mental illness. Kaler argued that Kansas' abolition of the broader insanity defense violated his constitutional rights under the 8th and 14th Amendments. However, the Supreme Court did rule 6-3 in favor of Kansas, holding that states have the authority to define the criteria for criminal responsibility, including the decision to abolish the traditional insanity defense. So with that being said, we're going to dive right into the analysis, starting with police. Police officers are the gatekeepers of the criminal justice system. That being said, although they are the first responders to individuals experiencing mental health crises, many lack the specialized training necessary to manage these situations effectively. This can lead to tragic outcomes and exacerbates the difficulties faced by mentally ill individuals. A study conducted by the Treatment Advocacy Center in 2015 found that the average police recruit spends 58 hours on firearm training, but only 8 hours on mental health crisis intervention. This disparity highlights the insufficient emphasis placed on mental health training compared to other aspects of police work. So 2 examples to look at that show the lack of mental health training include Daniel Prude and Keith Vidal. In March of 2020, Daniel Prude was an African-American man experiencing a mental health episode, and he died after being restrained by police officers in Rochester, New York. Prude was naked, he was acting erratically, and he was in the middle of the streets when officers arrived. So instead of using de-escalation techniques, the officers placed a hood over his head and pinned him to the ground, leading to his asphyxiation, which means he could not breathe. The incident sparked outrage and highlighted the critical need for better training in handling mental health crises. In 2014, 18-year-old Keith Vidal had schizophrenia and was fatally shot by police in North Carolina. Vidal's family had called for help during a psychotic episode. Initially, 2 responding officers attempted to de-escalate the situation. However, when a 3rd officer arrived, the officer immediately opened fire, shooting Vidal, believing that he posed a threat. So this case underscores how a lack of consistent training and communication among officers can lead to fatal outcomes for mentally ill individuals. Moving on to the crisis intervention team. Does it work and how effective is it? Crisis intervention teams represent a promising model for improving police interactions with mentally ill individuals. CIT programs provide officers with specialized training in mental health awareness and de-escalation techniques. Studies have shown that CIT programs can reduce the use of force, lower arrest rates, and improve outcomes for individuals experiencing mental health crises. So Memphis, Tennessee was one of the first cities to implement a CIT program, and since its inception in the late 1980s, the program has had great success and has been credited with reducing injuries to both officers and individuals with mental illness. Now, although this program has had great success, the program has not been widespread. Many police departments across the country lack these programs, even though they have shown high success rate when it comes to the interactions of police officers and those who are mentally ill. So if a program is working, why is it not being implemented in other places, especially with the high amount of cases dealing with those who are mentally ill? After the police, we're going to focus on the courts. The court system plays a crucial role in determining the fate of individuals with mental illnesses who come into contact with the law. However, many judges, attorneys, and court staff lack adequate training in mental health issues, which can lead to misunderstandings, unfair legal proceedings, and inadequate outcomes for mentally ill defendants. Judges often have minimal education on mental health issues, which can impact their ability to make an informed decision regarding mentally ill defendants. The National Judicial College did a study in 2017 that found many judges received limited training on mental health, which may not be sufficient to understand the complexities of mental illness in the context of criminal behavior. So, looking at a case, the case of Indiana versus Edwards in 2008, the Supreme Court acknowledged that mental illness can impair a defendant's ability to represent themselves competently. However, the decision left significant discretion to judges to determine competency, highlighting the need for judges to have a deeper understanding of mental health issues in order to make fair assessments. That being said, court systems often lack sufficient access to mental health experts who can provide accurate assessments and testimony regarding a defendant's mental state. This shortage can lead to unreliable evaluations and unjust outcomes for mentally ill individuals. In Ford v. Wainwright of 1986, the Supreme Court held that executing individuals who are insane is unconstitutional. The case highlighted the critical need for accurate mental health assessments in determining competency and sanity, which requires access to qualified mental health professionals. There is also the issue of fear of faking. The fear of faking in the criminal justice system refers to concerns that individuals may exaggerate, fabricate, or simulate symptoms of mental illness to manipulate legal outcomes. This fear affects various aspects of the criminal justice process, from police encounters to courtroom proceedings and correctional settings. The potential consequences of malingering or faking are significant, leading to heightened scrutiny, skepticism, and can lead to false negatives, which ultimately results in dismissing a genuine case. Two good cases to look at when examining the fear of faking can go back to the beginning, looking at Kansas versus Kaler and San Francisco versus Sheehan. On to the law enforcement side of the court section, there is the Miranda rights. So as you know, I'm sure everyone knows the Miranda rights. You have the right to remain silent. Anything you can and say will be used against you in the court of law. You have the right to an attorney. If you cannot afford one will be appointed to you. Do you understand the rights I have just read to you? With these in mind, do you wish to speak to me? Miranda rights are crucial when dealing with the mentally ill because they protect individuals' constitutional rights during interactions with law enforcement. These rights ensure that a person understands they have the right to remain silent and the right to an attorney, which is particularly important for those with mental illness who may have impaired judgment, comprehension, or communication abilities. Without proper advisement or understanding of these rights, mentally ill individuals might unintentionally incriminate themselves or be unable to advocate for their legal interests effectively. So ensuring that they comprehend their Miranda rights helps prevent coercion and protects their due process rights during legal proceedings. So one case to look at is Moore v. Johnson of 1997. In this case, it focused on whether a defendant's Miranda rights were violated during police interrogation. So in this case, the defendant, Moore, argued that his confession was obtained in violation of his Miranda rights because he did not fully understand his rights due to limited education and his mental capacity. So the courts ultimately ruled against Moore, stating that there was sufficient evidence to show that he had been properly informed of his rights and that he had voluntarily waived them before making his confession. This case highlights the importance of ensuring that individuals, particularly those with limited mental capacity or education like Moore, truly understand their rights, their Miranda rights to be exact. It underscores the need for law enforcement to take extra care when dealing with a vulnerable population like the mentally ill to ensure that their constitutional rights are protected during interrogations. So kind of on that same track, a study by McGregor and Rost in 2021 explored whether individuals with language impairments adequately understand the legal rights conveyed in Miranda warnings. So the researchers found that citizens with language impairments often struggle to fully grasp the complex language and legal concepts embedded in the Miranda warnings, which ultimately can lead to misunderstandings about their rights. The study highlights the importance of ensuring that legal communications are accessible to all individuals, particularly those with language impairments, to safeguard their rights during legal proceedings. The last slide, focusing on the courts, is focused mainly on competence to stand trial. So competence to stand trial refers to a defendant's ability to understand the nature of the legal proceedings against them and to participate in their own defense. So in dealing with the mentally ill, assessing competence is crucial because it ensures that the individual can effectively engage with their attorney, comprehend the charges and potential consequences, and make informed decisions about their case. So if a defendant is found incompetent, they may undergo treatment to restore their competence before the trial can proceed. This process is crucial for upholding the fairness and integrity of the legal system, as trying someone who cannot understand the proceedings would violate their right to a fair trial. So the study conducted by Cox, Zaff, and Cooper focused on evaluating the competence of mentally ill defendants to stand trial. The researchers examined how mental illness impacts a defendant's ability to understand legal proceedings and participate in their defense. Their study aimed to identify the impairments, psychiatric symptoms, and the severity of mental illness. The study's findings highlighted that certain mental health conditions, particularly those that affect cognitive functions, are more likely to result in a defendant being deemed incompetent to stand trial. Additionally, the research emphasized the importance of accurate and thorough assessments by mental health professionals to ensure that defendants receive the appropriate support and treatment to restore competence when possible. Overall, the study underscored the critical role of mental health evaluations in the legal process, ensuring that the rights of the mentally ill defendants are protected and that they receive fair treatment within the justice system. We will now move on to the corrections portion. The correction system, encompassing jails and prison, frequently struggles to meet the needs of mentally ill inmates due to insufficient training and resources for correctional officers. So many officers are trained primarily in maintaining order and security, which means they have minimal focus on recognizing and addressing mental health issues, which can lead to inadequate care and increased violence and in self-harm among inmates. This lack of specialized training may result in misidentification of mental illness, further compounding the challenges faced by these individuals. Mentally ill inmates are also disproportionately subjected to solitary confinement, which can worsen their conditions by increasing anxiety, depression, and even psychosis. Furthermore, the shortage of mental health professionals in correctional facilities contributes to long waits for treatment and inadequate care, with facilities often relying too heavily on medication, while neglecting other essential therapeutic interventions such as counseling and rehabilitation. Focusing more on the solitary confinement aspect, Nelson Mandela's use of solitary confinement during his imprisonment is a significant aspect of his story. Mandela was placed in solitary confinement for extended periods as part of the harsh conditions imposed by the regime in South Africa. This form of punishment was intended to isolate him from other prisoners and weaken his resolve. So, despite the severe psychological impact, Mandela remained a symbol of resistance and strength. His experiences highlighted the detrimental effects of solitary confinement, including severe psychological distress, which can exacerbate mental health issues and diminish one's ability to cope with imprisonment. Mandela's endurance and resilience under these conditions became emblematic of his broader struggle for justice and equality. The updated Mandela Rules adopted by the United Nations in 2015 establish international standards for treatment of prisoners, which includes guidelines on solitary confinement. So, named in honor of Nelson Mandela, of course, these rules aim to improve prison conditions and ensure the humane treatment of inmates. So, focusing on Suicide Watch, there are two different levels of observation, and Suicide Watch is a monitored procedure used in correctional facilities to prevent inmates from self-harming or attempting suicide. So, going back to the two different levels, the first is 15-minute watch. So, a 15-minute watch, also known as 15-minute observation, involves staff checking on the inmate every 15 minutes. So this is generally used for inmates who are considered a risk for self-harm or suicide, but not deemed like an immediate danger. So during these checks, they just confirm the safety and the well-being of the inmate, documenting each observation. So after 15-minute watch, there's continuous watch. So a continuous watch sounds pretty self-explanatory, as does 15-minute watch. Consecutive watch, which is also referred to as constant or continuous observation. This is more intense than the 15-minute watch, and they are observed by the correctional officer or the staff at all times. So they are typically observed through direct visual contact, not necessarily over the cameras throughout the facility. So this level of supervision is for inmates deemed at immediate risk of self-harm or suicide. So both monitoring strategies are essential components of suicide prevention protocols in these correctional facilities. While in suicide watch, inmates are also put in suicide-resistant cells, which means that there are no tools that inmates have access to, like bedding or rails that they could use as a way to harm themselves. They are stripped of clothing. They are not given utensils like forks, knives, spoons, or any sanitary needs. And then to leave suicide watch, mental health evaluations must be conducted. So it kind of takes the extra precaution just to make sure that the inmates are in the right state of mind. Staying on the path of suicide. Suicide is the leading cause of death in correctional facilities. According to a report by the Bureau of Justice Statistics, the suicide rate in U.S. jails was 50 per 100,000 inmates in 2019, which is significantly higher than the general population rate. So this discrepancy underscores the need for targeted interventions within the prison system. Correctional officers are tasked with maintaining security and order within facilities, as stated before, but they also interact closely with these inmates daily. So without the adequate training, these officers can miss signs of mental health issues, which leads to delayed or inappropriate responses. A study by Martin and Henningsen in 2021 found that officers who received specialized mental health training were more likely to identify and respond effectively to inmates in crisis, highlighting the importance of such training programs. Several high-profile cases have brought attention to the link between solitary confinement and inmate suicide. So, for instance, Kalief Browder was a young inmate held in solitary confinement at Rikers Island and committed suicide after his release, having endured severe mental trauma during his incarceration. With that, data from the American Public Health Association in 2019 indicates that inmates in solitary confinement are nearly 7 times more likely to attempt suicide, whether in prison or out, than those in the general population. To address the high suicide rates in correctional facility, comprehensive reforms are needed. These reforms should focus on improving mental health training for correctional officers and reducing the use of solitary confinement. So with all of that taken into consideration, there we go, there are social implications for the police as to if they were to receive the proper mental health training to adequately assist these that are suffering from mental illness. So obviously some positives would be a reduction in the use of force, decreased incarceration rates, enhanced public safety, increased access to mental health, reduction in stigma, and strengthened community relations. Some negatives would be increased burden on law enforcement, inadequate training and implementation, continued criminalization of mental illness, potential misuse or misinterpretation of the training, and an erosion of community trust. With the courts, some positives would be a fairer and more compassionate trials, enhanced public trust in the justice system itself, and decreased incarceration rates. Negatives, of course, would be resource allocation challenges, potential for misuse or inadequate implementation, and challenges in balancing public safety and compassion. And lastly, for corrections, some positives would be improved treatments and care, reduce recidivism rates, very important, improve working conditions for staff, decreased incidents of violence and misconduct. And of course, the negatives, resource allocations challenges, challenges in implementation, and public safety concerns. So with all of that taken into consideration, I threw a lot of information on you guys. The criminal justice system lacks the proper training for police officers, court officials, and correctional staff in handling mental illness, which can lead to numerous negative outcomes, such as excessive use of force, wrongful arrest, unjust legal decisions, and inadequate mental health care in prisons. Cases like those of Daniel Prude and Keith Vidal highlight the urgent need for enhancing training in mental health issues. Of course, Daniel Prude and Keith Vidal are not the only cases to look at. We do have more recents like George Floyd. Those put an emphasis focusing specifically on the information talked about throughout this PowerPoint, like the George Floyd case. While programs like crisis intervention teams show promise, their limited application points to the necessary for wider implementation and investment in specialized training. Additionally, the court system inadequate training for judges, attorneys, and court staff results in misunderstandings and insufficient access to mental health experts, which exacerbates legal challenges for mentally ill defendants. In the correction system, the lack of proper training in mental health services has severe and often tragic effects on inmates. To address these issues, comprehensive training programs, expanded CITs, increased mental health courts, improved mental health care in prisons, and better collaboration with mental health professionals are crucial. These measures are vital for ensuring fair treatment, reducing recidivism, and improving outcomes for mentally ill individuals within the criminal justice system. These are my references. Thank you for watching my presentation. I hope you enjoyed it and I hope you learned a lot. Thank you.